Court does call the case. People of the state of Michigan versus Anitra Comer.
Before we even hear the first name called, understand this. What you're about to watch isn't one case. It's a snapshot of an entire courtroom ecosystem. In just over half an hour, we'll see plea deals, bond decisions, competency referrals, firearm charges, alcohol-related offenses, and defendants learning, sometimes in real time, how serious the justice system can be. Judge Simpson is running a fast-moving docket, and that pace matters. When courts move quickly, mistakes get exposed, nerves show, and defendants don't always have time to hide behind rehearsed answers. Pay attention to how differently each person enters this courtroom. Some arrive prepared, represented, and ready to resolve matters. Others are confused, defensive, or clearly overwhelmed. Those contrasts tell you a lot about outcomes before a ruling is ever announced. And though this opening stretch sets the tone, adjournments requested, bond continued, permissions granted. On paper, it sounds routine. But routine is where patterns emerge. Who gets time? Who gets scrutiny? Who gets sympathy? And who doesn't? As you watch, ask yourself this. Should efficiency ever come at the cost of deeper examination? Or is this exactly how justice is supposed to function on a crowded docket? Because by the end of this session, that question becomes impossible to ignore.
APA Rachel McDuffie for the people.
Good morning, Your Honor. Student Attorney Kara Rosengren requesting permission to practice under Michigan Court Rule 8.120 under the supervision of APD Stephanie Cannon on behalf of Ms. Comer.
Permission to practice is granted.
Thank you so much, Your Honor.
Ms. Comer, can you state your name, please?
Anitra Comer.
All right, thank you. Yes, okay, and what are we doing on this?
Your Honor, we are requesting to adjourn for 2 weeks so that we can have a client consultation in person with Ms. Comer at the Women's Correctional Facility.
All right. Is 2 weeks going to be enough to work through the process? Al,
I believe so.
think so. All right. 2 weeks notice. What?
Thank you.
Full cause conference in this matter will be adjourned June 26, 2025, 9 a.m. Bond will continue. Thank you.
Thank you.
This is a quiet moment, but it matters more than it sounds. An adjournment with bond continuing tells us two things immediately. First, the court does not currently see Ms. Comer as an imminent risk. Second, the system is acknowledging a practical reality. Meaningful legal representation sometimes requires face-to-face consultation, especially when a defendant is already incarcerated. What's important here is what didn't happen. The judge didn't push back. He didn't shorten the timeline. He didn't impose new bond conditions. That signals procedural trust. Courts don't grant these requests automatically. They do it when counsel shows credibility and preparation. For viewers, this is where courtroom dynamics begin. Judges read lawyers quickly. One solid request early in a docket can shape how later arguments are received. And then this 2-week delay might look minor, but delays can change leverage, plea strategy, and even outcomes. Now think about this. If you were the defendant, would you rather push forward quickly or take more time to prepare, knowing every extra day keeps you in limbo? Drop your thoughts below, because this trade-off shows up again and again throughout this docket.
Let's call the case of the people versus Aiden Evans.
Alexander on behalf of the people, Your Honor.
Morning, Your Honor. Chris Eastup appearing on behalf and with Aiden Evans, who is present. Mr. Evans, you step up and state your name for the record.
My name is Aiden Evans.
I have a plea form in front of me. Is that what we're doing today?
It is, Your Honor.
The plea form indicates that the defendant will be pleading guilty to the charge of illegal entry, the 90-day offense. Upon a successful plea to that charge, count 1 would be dismissed, and that the parties agree to sentencing under HIDA. Of course, the court can't bind the sentencing judges. All right.
That's correct, Your Honor.
May I have him sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the true self you got.
Yes, sir.
State your name.
Aiden Jack Evans.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of illegal entry. That's a misdemeanor punishable by up to 90 days, $500 fine plus court costs. Do you understand that?
Yes, sir.
All right. You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You
Yes, Your
understand
Honor.
that, sir?
Yes, Your Honor.
All right, understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
I plead guilty, Your Honor.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal upright.
Yes, Your Honor.
Are you on probation or parole?
Parole, Your Honor.
No.
Oh, no.
That's bond.
Parole.
Bond.
Bond.
Okay.
That's how new he is.
Yes. All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will?
Correct.
Yes.
Yes.
And because you believe that you're guilty of this offense?
Yes.
May 25th, 2025, at the location of 1043 North Main Street, City of Ann Arbor, Washtenaw County, State of Michigan. What'd you do on that date that makes you think that you're guilty?
I entered the premise without permission from the resident.
So you entered somebody's house,
Yes, Your Honor.
apartment, and you didn't have their permission to enter those premises,
Yes.
and you had no property interest or other thing in that property. Now, counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
That's satisfied with.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed.
This is a textbook plea colloquy, and Judge Simpson runs it cleanly. Every right is explained, every waiver confirmed, and every answer locked into the record. Why does that matter? Because pleas get challenged later, and when they do, transcripts like this are the court's shield. Notice how the defendant briefly confuses bond with parole. That's not unusual, but it's revealing. It shows how unfamiliar many defendants are with the system they're navigating. And yet, legally, confusion doesn't stop the process unless it rises to incompetence. The court clarified, confirmed understanding, and moved on. The dismissal of count 1 is the incentive here. In exchange, the defendant admits illegal entry. No trial, no appeal, no second chances. Sentencing is kicked to another judge, which adds uncertainty. A plea doesn't end stress. It relocates it. Ask yourself this: would you take a guaranteed lesser conviction now or risk trial for a chance at full acquittal later? Because that question defines nearly every plea you're about to see today.
Pre-sentence investigation and report is ordered at the district court probation. Sentencing will be
July 1st at 9 a.m. for Judge Mello.
July 1st, 2025, 9 a.m. before Judge Simpson. Bond with its conditions will continue.
Thank you, Your Honor.
Thank you.
We still having them check out at the window after plea, or do they just get their stuff? They make up their own.
I don't. No. You should always check out according to Dan.
Thank you very much.
Really? Just do what she says. Court calls the case, People versus Terrell Green.
APA Richard McDuffie for the people.
Good morning. Assistant Public Defender Lauren Perny on behalf of Mr. Green. Mr. Green, please state your name for the record.
Terrell Green. Thank you. All right, Mr. Green?
Yes.
I have, you're here on one case. I have 2 other cases where you need to be arraigned on those cases. And so we'll go through that process if they put my paperwork in here. Starting first with the case 25F55605. In that case, sir, the complaint alleges that on or about May 3rd, 2024, at the location of 225 Briarwood Circle, City of Ann Arbor, Washtenaw County, State of Michigan, that you did commit the offense of uttering and publishing. Do you understand the nature of that charge, sir?
Yes.
All right. That is a felony punishable by up to 14 years incarceration. You understand that, sir?
Yes.
All right. On the other matter, the case ending in 600, that complaint alleges that between the dates of April 10th, 2024 and April 11th, 2024, at the location of 423 East Duncan Street in Manchester, Washtenaw County, State of Michigan, that count one alleges that you did steal or retain without consent a financial transaction device. Do you understand the nature of that charge?
Yes.
That is a felony punishable by up to 4 years incarceration and a $5,000 fine plus court costs. Do you understand that?
Yes.
Count two alleges the offense of breaking and entering a vehicle with the intent to steal property less than $200. You understand that charge, sir?
Yes.
All right. There is a second or subsequent offense notice, which makes this a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property stolen. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes.
All right. First question I have for you, sir, is do you wish to be represented by an attorney?
Yes.
All right. These are public defendants.
Your Honor, regarding both arraignments, we waive formal reading, stand mute to the charges. And I'm sorry,
Go ahead.
on all 3 cases, I'd request a pretrial date.
Probable cause conference.
I'm sorry, probable cause conference. Yes,
All right. You waive time limits.
yes, Your Honor.
And you're asking for an adjournment on the other one.
Yes, he's going to be in Livingston, I believe, until September 30th.
Got it.
And we just want to review everything together and see what happens. Obviously, these are new cases.
All right. On these cases, I will adjourn the one case and set the probable cause conference for June 26, 2025 at 9 a.m. All right. And I'll get to the bond issue. Let's start with the Ann Arbor case first. Anything you want to say regarding bond?
No, Your Honor, I just asked for a nominal bond. As I said, Mr. Green is going to be in Livingston County until the end of September.
All right. Anything from the people?
Your Honor, on the, pardon me, on both of the cases, we requested a surety bond of $7,500. And with the reasons explained below, there's a no go-to request on this file for the DFCU financial branch at 25 Briarwood Circle. And I don't believe there's any no contact. That's the only other condition outside of the normal line conditions on this file.
I'll indicate he's not to go to 25 Briarwood Circle on that case. I will set his bond at a $5,000 10% bond.
Here's where bond decisions become more than numbers. They become leverage. A $5,000 10% bond means Mr. Green needs $500 to secure release, assuming no holds elsewhere. That's manageable for some, impossible for others, and that difference often dictates whether someone can meaningfully participate in their own defense. The court carefully tailors conditions: no alcohol, no drugs, no weapons, and specific no-go locations. This isn't random. These conditions are directly tied to the alleged conduct: financial crimes, break-ins, and repeat behavior. Judges look for patterns, and restrictions follow those patterns. What's especially notable is the decision not to require cash surety. That suggests the court believes compliance is achievable without extreme financial pressure. It's a balancing act between public safety and presumption of innocence. But here's the bigger question: do bond conditions actually prevent future misconduct, or do they simply create more opportunities for violation? We'll see that tension resurface later in this docket in a much more dramatic way.
I don't know that there's a necessity to have a cash or surety on this case. I will order standard conditions, including no assaultive behavior or possession of any weapons, no alcohol consumption or possession. Also, that applies for recreational marijuana and no illegal drug. Dated, I said 6/26.
Yes, sir.
On the other matter,
there is a request for no contact with Susan Furda, F-U-R-D-A, as she is a victim in this case. I also requested a no go-to, actually within a 1 mile radius of 423 East Duncan Street in Manchester, as this was a case of break-ins with multiple homes in that neighborhood.
how was her last name spelled?
F-U-R-D-A.
I have no objection to that, Your Honor.
Bond in this case will be set as a $5,000, 10% bond. It will indicate that there's to be no contact with Berta, and he's not to enter the township of Manchester. Anything else on that?
You want that no go to as well on that file?
He's not to enter the township of Manchester.
Oh, okay, I didn't hear you. Thank you.
Nothing else for me, Your Honor.
All right, thank you. Thank you, sir.
I'll be in touch, Mr. Green.
Court calls case People versus Ardeen Henderson.
And for that is for the people?
Good morning, Your Honor. Ken Madadish on behalf of Ms. Henderson, who is appearing by Zoom. Ms. Henderson, can you please state your name for the record?
Ardeen Henderson.
Thank you.
You're welcome.
Requesting an adjournment.
Yes, Your Honor, we are going to refer her to our AIM division and to continue plea negotiations with the prosecutor's office.
How long is she going to be in Wayne County Jail? Does she know?
A while. I believe they're doing a competency report there. So it's gonna take a minute.
So
we can adjourn it out
So there's a comp on her case there?
there. Yes. I'm debating whether I need to talk to
Council approach.
the seniors in our office.
Council approach.
Yeah.
Or you can keep talking. Council approach.
Oh, council approach. I think that's an approach.
Okay, on this case, what I will do is I'll adjourn the probable cause conference, understanding that I may get a request for a competency or forensic evaluation to coincide with the one in Wayne County, but I'll adjourn this to, we'll just do July 10th initially, and then we'll see where we are.
Thank you, Your Honor.
Competency discussions always change the tone of a courtroom. Once mental fitness enters the conversation, the goal shifts from punishment to assessment. The court is no longer asking, "What did you do?" but "Can you meaningfully participate in this process?" Judge Simpson's approach here is deliberate. He doesn't rush. He aligns timelines with existing evaluations in another county. That coordination matters because conflicting competency findings can derail cases for months or years. For viewers, this is where criminal law intersects with mental health systems that are already stretched thin. Evaluations take time. Jail stays get longer, and defendants often remain in limbo without resolution. Ask yourself, is this system protecting vulnerable individuals or trapping them in procedural delay? Because depending on perspective, this adjournment can look like compassion or stagnation.
July 10th, 2025, 9 a.m. On continue.
Thank you.
Court calls case of the People versus Aaron Fromm.
Sherilyn Foster Tucker on behalf of Aaron Fromm.
Aaron Fromm.
And Your Honor, we're just requesting a brief adjournment to review discovery.
Probable cause conference will be June 17th, 2025, 9 a.m. That's Tuesday. Bond will continue.
Thank you, Your Honor.
Court calls case of the People versus Winona Harvey. Chinaza.
We're going to grab it right now, Your Honor.
Really? Ma'am, state your name.
Winona Michelle.
Thank you. Where is she? Somebody needs to get her in here or have somebody that can cover this case now. Thank you, Mr. Gaddy.
Morning, Judge Mike Gaddy on behalf of Ms. Harvey. Have you spoken?
Yes.
Okay. What's gonna
So, we're gonna talk about somebody that I hit.
Okay. No, did she tell you whether the case was going to?
Yeah.
Did she say she was going to adjourn it?
No.
Yeah, I think this may be a referral.
Parental.
Yeah, sure. I'm trying to.
She told me that I'm here about a case about putting my hands on an officer at the correctional facility.
Okay.
That's what I'm here for today.
Yeah, Your Honor, we're going to refer this for competency. I'll prepare the competency referral and the, criminal responsibility referral forthwith.
Forensic evaluation is ordered. I'll set a competency hearing for August 28th, 2025.
Thank you.
9 a.m.
Thank you, Your Honor.
This moment underscores how seriously courts treat allegations involving violence against officers, especially inside correctional facilities. Even before guilt is determined, the response is procedural caution. Competency and criminal responsibility evaluations act as safeguards, not shortcuts. The defendant's own explanation is fragmented, uncertain, and emotionally charged. That alone doesn't establish incompetence, but it raises enough concern to slow everything down. Judges are trained to spot these red flags quickly. What many viewers don't realize is that competency hearings can drastically alter case trajectories. Charges may be paused indefinitely. Treatment may replace prosecution, or, after evaluation, everything resumes exactly where it left off. So here's the question. Should competency evaluations be more common? Given how many defendants struggle to articulate what's happening to them, or does overuse risk clogging an already overloaded system?
Court calls case People versus Charles Tingley.
Your Honor, good morning. Joe Simon on behalf of Mr. Tingley, who should be by Zoom.
I am Charles Tingley.
Okay, I'll need a camera.
He's just here.
All right, there he is. Okay.
Your Honor, I'm informed that the long-awaited contract with Detective Babbage in the county has been signed, and we are asking the court to grant our request for another adjournment. We're trying to be one of the first cases in line since we've been waiting, but I can't assure you of that. So,
what's the anticipated time frame?
Well,
The only information I have is that I believe the contract has been signed, and so he's going to start scheduling them.
Got it.
So maybe 3 weeks, if that's.
Unfortunately, I'll be gone at that time. So, but
beautiful. We'll set it then.
Thank you, Your Honor. Very kind.
No, I want you around because you're around and Miss Landy's there. We learn things.
We do further our education. That is true.
I'm so full of nothing. I am. It's a joyous time when you learn things.
It is.
So
that is true.
What date do you want?
Your Honor, could we possibly go to July 10?
Is there any objection from the people? Probable cause conference, July 10, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
I think that's the quietest Landy's ever been. All right. Bond will continue. Thank you.
This exchange is lighter on the surface, but it reveals something important. Courtroom culture. Judge Simpson allows humor, rapport, and brief philosophical asides, but only because control is never lost. That balance keeps proceedings human without undermining authority. Continuing bond here signals stability. No new allegations, no compliance issues, no reason to escalate. In busy dockets, uneventful decisions are victories. They mean the system is functioning as intended, but don't miss the subtext. Adjournments stack, delays compound, and every continuation pushes resolution further down the road. For defendants, that can mean months of uncertainty, even when nothing bad is happening. Is consistency enough, or should courts push harder for faster resolution when cases stall? That tension sits quietly behind moments like this.
Thank you, Your Honor.
Case People versus Christopher Gilmore.
Alexander, on behalf of the people, Your Honor.
Good morning, Your Honor. Wendy Burnwell standing in for the attorney of record, Kareem Johnson.
Good morning. Your name, sir?
Christopher Gilmore. Good morning, Your Honor.
Good morning. And you have no objection, Barnwell stepping in?
No, sir.
All right. All right, what are we doing?
Your Honor, Mr. Johnson has indicated that he received all discovery and he wishes to set exam dates on both cases.
People have the witnesses available on the 17th.
Whereabouts, Your Honor?
You said June 17, Judge?
Yes, sir. Yes, ma'am.
When did
Preliminary examination in these matters in person, June 17th, 2025, 9 a.m. That is before Judge Moore.
Thanks today. If I can leave.
Your Honor, there's an ongoing discussion because my client wishes, Mr. Johnson's client wishes to have permission to leave the state. However, I'm indicating to him that the court would want that in writing. And the court would want
What's
defense
his
counsel,
purpose for leaving the state?
right?
I was, Your Honor, I'm about to turn a new leaf, Your Honor.
Pardon?
Can't just, the case has to be resolved.
All right.
You just want to leave the state?
Yes, I'm tired of getting in trouble. My summer, I don't want to spend my.
You don't like the great mittens to the north? Go ahead. You just want to leave the state while criminal charges are pending? Probably is not going to happen.
This is a reality check, plain and simple. Wanting to turn a new leaf is not a legal strategy. Courts deal in compliance, not intentions. Leaving the state while charges are pending raises immediate flight risk concerns, and Judge Simpson shuts it down without hesitation. The judge's tone matters here. It's firm, not cruel. He explains without shaming. That clarity is intentional. Defendants often test boundaries verbally before acting on them. Courts respond by drawing lines early. For viewers, this moment highlights how personal plans collide with legal obligations. Summer, travel, fresh starts. None of that outweighs unresolved charges. The system demands accountability first, freedom second. Would you have even asked? And if so, how would you react to a hard no like this? Let that sink in as we move forward.
All right, thank you so much.
Yep, okay, great. That's glad we're.
Can't do it.
Thank you.
Have a good one. Yep.
That was easy. Court calls the case, People versus Marvin Sullivan.
Ready, Your Honor. Your children appearing on behalf of the people, Your Honor.
James Fifelski appearing on behalf of Mr. Sullivan, who is approaching. Can you state your name for the judge, please?
Marvin Sullivan.
Your Honor, at this time, we will ask the court to set this for preliminary
All
examination.
discovery is complete.
Yes, Your Honor.
People have their witnesses available the 17th.
Is it any way possible to go 1 week to the 24th? And I will represent the court. I understand that Mr. Sullivan has a hearing in front of Judge Conlon on an extradition on the 25th. So I don't think this would be holding him any longer than he on this case than he would be otherwise.
I'll leave it to the court's discretion.
Their examination in person, June 24th, 2025, 9 a.m. before Judge. Fresh hour. Bond continued.
Thank you, Your Honor.
Court does call the case of People versus Alexander. Is it Bounds?
For those for the people.
Your Honor, Student Attorney Kara Rosengren, under the supervision of APD Stephanie Cannon, on behalf of Mr. Bounds. Mr. Bounds, could you state your name for the court?
Alexander Bounds.
Your Honor, we're requesting that the court set a date for Mr. Brown's preliminary exam.
All discovery is complete.
Yes.
People have their witnesses available the 17th. Preliminary examination in person, June 17th, 2025. Now that's at 12 noon. That is before me.
Thank you, Your Honor.
Bond continued. Thank you, sir. That's in person. Court does call the case of the People versus Elliot Kazan.
Ready, Your Honor.
Ashley for the people.
Oh, you're still here.
I return, Your Honor.
Oh. Picking
Joe
up knowledge. I'm sorry.
Joe Simon on behalf of Mr. Kazan. Your Honor.
Your name, sir?
Elliot Kazan.
Thank you.
Your Honor, I may request approach the bench, but I'm a little afraid. The last time we were here, we were about ready to enter a plea. Then we had our bond issue. The people have maintained the offer. My client wants to accept it. But could we approach briefly?
Yes, you can.
Thank you.
Oh, it's both you two.
Yeah, that's all. And to be clear, Your Honor, my client did fill out previously an advice of rights form that I reread.
Wait, that was riding lawnmowers. Right, go ahead.
I'm sorry, Your Honor. My client did previously fill out an advice of rights form, but I re-reviewed that with him. And he knows that he previously filled out a sentencing judge waiver, but he also knows I've reviewed that with him as well. Please write it in, please.
All right. The plea form in this case indicates that the defendant will be pleading to 3 charges. That he will be pleading to the possession of a firearm under the influence, the actual stated count 3, as well as an addition, and that's the 93-day misdemeanor. He will be pleading also to operating while visibly impaired first, a 93-day misdemeanor. and will be pleading to attempted possession of a loaded firearm in a motor vehicle. And I believe that's a 1 year. It's not on.
That is a 1 year, Your Honor, and I do believe mandatory forfeiture is a component of the offenses the defendant will be pleading to as well.
That's 1 year. Fines on that are,
1,000?
yeah, I think so. I think that's right. All right. And then counts 1 and 2 would be dismissed. And
Agreeing at the time of sentencing not to.
no upfront jail if defendant remains compliant.
Correct.
Okay. All right. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
State your name.
Elliot Kazan.
All right, sir. It is this court's understanding that you are going to be pleading guilty to 3 misdemeanor charges. Is that your understanding?
Yes, Your Honor.
All right. First charge is a stated count 3 of possession of a firearm under the influence. That's a misdemeanor punishable by up to 93 days in jail, a $100 to $500 fine plus court costs if you are using and or discharging the firearm. Also mandatory forfeiture of the weapon or device. You understand this?
Yes, Your Honor.
All right. Also, this court's understanding you're going to plead guilty to the charge of operating while visibly impaired first offense. That's a misdemeanor punishable by up to 93 days in jail, $300 fine plus court costs. Court could order rehabilitative services or any community service court deems necessary. Court could order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
All right. Also, count 5 of attempted possession of a loaded firearm in a motor vehicle. That's a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. You understand that? And also mandatory forfeiture of the device. You understand that?
Yes, Your Honor.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court.
Yes, Your Honor.
Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
All right. To the charge of possession of a firearm under the influence, how do you plead?
Guilty.
To the charge of operating while visibly impaired, how do you plead?
Guilty.
To the charge of attempted possession of a firearm in a motor vehicle, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of right form previously, is that correct?
Yes, Your Honor.
Any questions regarding those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today in the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty of these offenses?
Yes, Your Honor.
June 22nd, 2023, at the location of Jackson Road near Stabler Road, Scioto Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, Your Honor.
What'd you have and how much, if you recall?
5 to 6 beers.
Were you stopped by the police or was there an accident?
I was stopped by the police,
Why'd they stop you?
rolling through a stop sign.
All right. Were you ultimately arrested?
Yes, Your Honor.
Were you taken to the station or hospital for a blood draw?
Yes, Your Honor.
And what were the results of that blood draw?
0.095 blood alcohol level.
Do you have any reason to dispute those blood test results?
No, Your Honor.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
In that motor vehicle that you were driving, did you have a firearm in it?
Yes, Your Honor.
And where was it?
In the glove box.
All right. And did you have authority to carry that firearm in that fashion in that?
No, Your Honor.
And I think that's and at the time you were under the influence and you had possession of that firearm.
Yes, Your Honor.
Counsel?
Was the firearm loaded?
No, Your Honor.
Well, actually, what?
Yes, it
actually.
Okay.
Yeah.
Was
Yes,
the
Your
firearm
Honor.
loaded?
Yes, I had, yes.
All right.
In the magazine, not the chamber.
Yes. In the magazine, not the chamber. Yes.
Nevertheless, that constitutes.
Yeah. Same, yeah.
All right. Now, counsel, have I complied with the court rule?
I'm satisfied, Your Honor. Thank you.
Yes, Your Honor.
Court will accept the defendant's pleas of guilty to counts 3, 4, and 5. 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be June 16, 2025, 9 a.m. Fresh hour. Esteban.
Your Honor, we are requesting the court reinstate my client's bond. His original bond was 5,000, personal recognizance 5,000. He was ordered to community corrections to participate in sober link testing. The last time we were here, we offered to switch from that to a scram tether. That's our request, is to reinstate bond with the scram alcohol tether.
Anything from the people?
Yeah, the people's concern is that the defendant not be consuming, so a scram tether will accomplish that goal at this time.
I'll reinstate the defendant's previous bond condition. So he set his bond $5,000 personal recognizance bond. The defendant is to be placed on a scram tether prior to his release. I will sign that order, and I know you're trying to work through that, so we'll sign it and make sure that it gets over there.
This is escalation through monitoring. Scram tethers aren't punishment, they're prevention. The court is sending a clear message. Freedom continues only with verification. Alcohol-related offenses combined with firearms leave zero margin for trust-based supervision. What stands out is the collaborative tone. Defense proposes an alternative. Prosecution agrees on the objective. The judge adopts a solution. This is the system working pragmatically, not adversarially. But monitoring comes at a cost: financial, physical, and psychological. Wearing a tether is a constant reminder of oversight. One violation, one false positive, one mistake, and bond disappears. So here's the question: is technology enhancing justice or replacing discretion with surveillance? Because devices like Scram are becoming the norm, not the exception.
Thank you very much, Your Honor.
Thank you, Your Honor.
All right, thank you.
Thank you.
Court does call the case People versus James Sharp.
People.
James Fifelski, appearing on behalf of James Sharp.
Mr. Sharp, can you state your name, please?
James Glenn Sharp, Your Honor.
Thank you, sir. What are we doing?
Your Honor, we're asking the court to set this for preliminary examination. Mr. Sharp does have sentencing on a federal case on June 17th. We'd ask the court to set it for the 24th.
Is all discovery complete?
Yes, Your Honor.
Do people have their witnesses available on the 24th?
Sure, yes.
Preliminary examination in person, June 24th, 2025, 9 a.m. That is before Judge Washington.
Thank you very much, Your Honor.
We'll continue. Thank you. Court calls the case People versus Jody Williams.
Ready, Your Honor.
Alexander, on behalf of the people, Your Honor.
You're just everywhere.
Pardon?
You're everywhere.
It's been tough. I'll get my steps in. Joe Simon on behalf of Ms. Williams. Jody, state your name.
Jody Williams.
Thank you.
Your Honor, we're asking the matter be set for preliminary exam. And because you always know I never cause trouble for the court, what is the earliest possible? Because my travel dates are both on successive Tuesdays. I'd like to have this sooner than the 24th if possible. I travel on the 24th and then on July 1st. So.
Oh, so you want us to accommodate your scheduling?
If
on
possible.
Everything.
If possible.
That's an arrogance I haven't seen in a long time. Will the 17th work for you?
Yes.
All right. So
thank you.
Discovery is complete.
Yes.
Would the people have their witnesses available the 17th?
We'll do our best, Your Honor.
All right. Preliminary examination in person, June 17th, 2025. 9 a.m. That is before Judge Moore.
Wait for me outside, okay? Thank you. Oh,
bond will continue. Thank you.
Thank you, Your Honor.
Bye.
I'll see you on the next docket on Zoom. But Your Honor, I will say this: it's always an uplifting experience.
Back at you. That's all I got. Court calls the case People versus Wesley Brand.
Alexander, on behalf of the people, Your Honor.
Good morning, Your Honor. Wendy Burnwell on behalf of Mr. Wesley Yonder Brand.
All right. What are we doing? I think I have a conditional release.
They're going to address
violation.
Because you made a call and they're describing all this allegedly.
We have 17 complete calls to the victim since he was arraigned, as well as 84 total attempts in. So he's tried to call her a total of 84 times, with 17 of those calls getting through.
Counsel.
Your Honor, this
The
is,
bond violations, why don't we start there?
Your Honor, this is, I didn't have enough time to talk to him about the particular alleged bond violation, Judge.
This is where bond violations stop being technical and start becoming personal. 17 completed calls, 84 attempts. Those numbers matter because courts don't look at intent here. They look at behavior. And repeated contact attempts, especially after explicit bond conditions, signal disregard for court authority. Defense counsel is doing what they're supposed to do. Slow the process, request time, protect the client's procedural rights. But notice how limited that room is once a violation is alleged. Judges are far less flexible when someone is accused of ignoring direct court orders. The immediate takeaway for viewers is this: bond is conditional freedom, not a pause button. Every call, text, or attempt can become evidence. And once violations stack up, even sympathetic arguments lose weight fast. Ask yourself, if you were granted release under strict conditions, would you risk everything on just one more call? Because courts treat that choice very differently than defendants often expect.
I did read it yesterday. It was sent to me and I did read the bond violation.
And does he want it set for hearing or?
1 second, Judge.
To the violation?
Yes, Judge.
What are we gonna do?
Wishes to set it for a hearing, Judge.
All right.
I'm assuming it's another day.
Yes.
Okay.
Set a bond violation hearing. Well, adjourn the probable cause and set a bond violation hearing for June 12th, 2025.
Split second,
At
Judge.
3 p.m. Pending that hearing, defendant.
I'm here, Judge. I'm here in front of this court that same day.
All right.
So
that's at 3 p.m. And pending that hearing, defendant's phone privileges are hereby ordered revoked. His bond, however, is continued. Thank you.
So Judge will set an exam day on that day.
That's the wish.
Thank you.
Calls case people versus Derek Stewart.
APA Rachel McDuffie for the people.
Mr. Derek Stewart.
Assistant Public Defender Jay Bellinger on behalf of Mr. Stewart, it sounds like. Derek Stewart.
He's here.
Okay. Thank you. And Your Honor, obviously our office has not had any time to review his police report with him and the evidence. So
well, what is this say? It's set for a confidence.
It's just on the bond.
It's here on the bond by, and you know nothing about those, I take it.
That's correct, Your Honor.
On this matter, the defendant is in custody on this case, I think, as well as others. He's awaiting a review hearing, which is set for July 22nd, 2025. Well, he wouldn't have been, I think at this point he's being held on this alleged bond violation, because otherwise it wouldn't have occurred that way. So at this point, what I will do is I'll continue the defendant's bond as being revoked for the violation pending a hearing on this. There's a report that needs to be prepared, as well as I have shown counsel preliminary results, I guess, of the bond violation, which is possession of a weapon. So I'll set a bond violation hearing on this matter for June 26, 2025.
Alleged possession of a weapon while on bond is a game changer. Even without a final finding, the court treats this as a serious public safety concern. That's why bond is revoked pending hearing. Not modified, not restricted, but revoked. Notice the procedural care here. The judge references reports, shares preliminary results with counsel, and schedules a formal hearing. This isn't punishment, it's containment until facts are established. That distinction matters legally, even if it feels harsh to the defendant. From a systems perspective, this is where earlier decisions echo forward. Bond conditions only work if violations carry consequences. Otherwise, they're suggestions, not orders. Ask yourself, at what point does presumption of innocence yield to risk management? Because this moment sits right on that fault line.
At 3 p.m.
Your Honor.
All right, thank you.
This docket shows the justice system in its most practical form: fast, procedural, and uncompromising. We saw guilty pleas entered with precision, bond decisions calibrated to risk, competency evaluations ordered to protect due process, and bond violations met with swift consequences. Judge Simpson's courtroom makes one thing clear: rights are protected, but responsibility is enforced. Preparation earns patience, compliance earns trust, violations erase both. Across these cases, the broader implication is consistency. The rules apply whether the charge is minor or serious, whether the tone is light or tense. The system moves forward, always. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.